Politics and corruption have become twins nowadays. If you are a politician, people assume you as a corrupt. Is it good for the democracy? Hello friends, welcome to the InNews series of Drishti IAS. I am Ritu and today's session is about Supreme Court landmark verdict on bribery cases. And this session is important for your GS2 perspective. Moving towards the points of discussion part. First of all, we are going to discuss the news, then we'll have a brief idea about the case. Then we are also going to discuss the background of the case, which is the 1998 ruling that was being reconsidered, and also what is the verdict of the apex court regarding this thing, and then practice question for prelims. Before that, you have to like, share and subscribe to the Drishti IAS channel. Moving towards the news part. So, in the landmark judgment, Supreme Court had opined that members of parliament and members of legislative assembly will not provided any immunity in the case of bribery cases. And if any member of parliament or member of legislative assembly has taken bribery in order to cast their vote or in order to change their mindset regarding no confidence motion, then in that cases the immunity will not provided to the legislative assembly people and also the parliamentarians. So this is the landmark judgment which has been given by the Supreme Court yesterday. So that's why we have chosen this topic, and we are going to discuss today's topic. So moving towards the next slide. Next slide is about that what was the case. So Sita Soren, who was a member of Jharkhand Mukti Morcha, has asked the High Court to provide legal immunity under Article 194(2) of the Indian Constitution because she was a member of Legislative Assembly, and it has been alleged that she has changed her stance by taking bribery for casting vote in the Rajya Sabha election. So the matter reached to the High Court, but High Court did not accept this matter, and then Sita Soren moved to the Supreme Court, and after Supreme Court we have given this verdict, and the Supreme Court had made recommendations regarding this thing and some serious observation that why this case has become phenomenal, and an example for the politicians that whether they are politicians, whether they are representative of the people, whether they are member of parliamentarian or also whether they are member of legislative assembly, it's their duty that they should not take the bribe and to maintain transparency in the legislative assembly and also in the parliament. So this is the case. So what had happened that she earlier visited to the High Court and then Supreme Court, and eventually the matter reached to the Supreme Court on September 2023. A 5-judge bench headed by CJI Chandrachud doubted the correctness of the majority view in the P.V Narasimha case. And because this case has directly dealt with the P.V Narasimha Rao case, but this time the observation has made some correctness about the case, and Supreme Court has overruled its own judgment and made some corrections regarding their previous judgment which has been opined in P.V Narasimha Rao case. Moving to the next slide. Next slide is about that what was the 1998 ruling that was being reconsidered. So in 1998 there was a ruling by Supreme Court and the case is known as P.V Narasimha Rao case. In that case also the Shibu Soren, who was a father-in-law of Sita Soren, has been accused, and all his party members, few of his party members has been accused that they have accepted bribery in order to pass the no confidence motion against the Narasimha Rao government. So this was the allegation, and the matter reached to the court, and the court has observed that that bribery is a serious offence, but in order to maintain the debate and discussion culture of the parliament and also the legislative assembly, the parliamentarians and legislative assembly people will be provided immunity because whatever they did in the nature of the parliament or in the hour period of the parliament, it is immune. So that's why they have provided immunity into this case. Though the court has observed that bribery is a serious offence, but this time Supreme Court has overruled and made correctness in their own judgment. So moving to the next slide. Next slide is about that what did top court, it means the Supreme Court, observe and rule about this judgment. So the first observation is no violation of the doctrine of stare decisis. And what is the doctrine of stare decisis. So it is a legal principle that obligates judges to adhere to prior verdicts while ruling on a similar case. So it has been already said that this case has directly dealt with the P.V Narasimha Rao case. So many petitioners have argued that it is the duty of the Supreme Court that they should revisit their earlier judgment and to adhere all the judgment which has been given to the similar case. And Supreme Court has also given their opinion that we have revisited the judgment and we have made correctness regarding the judgment. And during the proceeding, the petitioners have raised a preliminary objection and the court has observed that such contention was dismissed by the observing that doctrine is not inflexible rule of law. So many petitioners have argued that they should visit the doctrine of this stare decisis. So Supreme Court has opined that okay, we accept this doctrine, but this doctrine is not inflexible rule of law. It means that it is not rigid in nature and it can be also amended, it can be also revisited, and it can also be correctness. And whatever the correctness made, it has been made by the larger bench. Earlier it was the 5-judge bench, now it is the 7-judge bench. So this is the thing. Moving to the other observation, the other observation is constitutional immunity from bribery charges does not fulfill twofold test. And while elaborating upon the purpose of Article 105 and Article 194 and what this article does, so these articles provide immunity to the parliamentarian. Article 105 provide immunity to the member of parliament, and similarly Article 194 also provide immunity to the member of legislative assembly, that whether they speak anything regarding the proceeding of the house, they are immune to that. So while proceeding, the purpose of Article 105 and 194, the Chief Justice pointed that such privileges are guaranteed to sustain an environment in which debate and discussion culture should be sustained, but that should not be misused. And here we have to acknowledge this fact that bribery is a serious offense and it erodes the foundation of democracy. So in that case, it's mandatory that court must intervene into this matter. And the second is that offense of a bribery not immune just because it is not essential to the way a vote is cast. So the Supreme Court has observed that there are two limbs, and the first limb is that member of parliament shall not be liable before any court in respect of anything said or vote given in the parliament. And also the second limb is that anything they publish in respect of the publication, there will be no action taken against them. But offense of bribery is not immune to such kind of the things. It means that if they speak anything in the parliament, okay, there will be no action to that person. But here bribery is a serious offense. So the bribery is not immune to such kind of the things. Moving to the other observation. So other observation made by the Supreme Court is offense of bribery completes the moment illegal gratification is taken. So the court has observed that many people have said that people take bribes and accept bribes, but they do not cast vote accordingly. Sometimes they take bribes, but they vote whatever their party mandate is. But the court has observed that the moment they accept the bribe, whether the location is anywhere, whether it's their home, whether it's in the parliament, whether it's in the legislative assembly, the location does not matter. The attempt to take bribe and also the acceptance of bribe matters, and that makes a serious offense. So that's why offense of bribery completes the moment illegal gratification is taken. So the moment the person has taken the bribe, the moment itself become a crime. So this is the observation taken by the Supreme Court. The next observation is courts and the houses can exercise parallel jurisdiction. So many petitioners have also argued that it is a matter of the house, and if any member has breached the privileges of the house, then it's the duty of the house that they will give punishment to that person. So the court have observed that house has their own rights and they can punish to a particular person. On the other hand, the bribery is a serious offense and it erodes the foundation of democracy. It breaks the trust of the people because they are the parliamentarians and they are elected by the people. So in that case, the court has right to intervene into this matter and they can take their jurisdiction parallelly to the house. It means that house can also take their action and the courts can also take their action. Moving to the other part. So other observation is corruption by legislator erodes the foundation of democracy. So the CJI Chandrachud has observed that corruption and bribery of members of legislature erode the foundation of Indian parliamentary democracy. I am repeatedly saying that the key term of this whole judgment and whole landmark observation is that the CJI has focused that if a member is elected by the people trust that person, and if they are committing such kind of serious offense, then it erodes the foundation of democracy, where everyone has equal right to speech and they express, and they have also right to assent. So in that sense, it is a very serious offense and it is very destructive for any country. And the last observation is legislative privileges apply equally to Rajya Sabha election. So the court has also clarified that principle enunciated in the verdict regarding the immunity provided to any person, the member of Legislative Assembly or the member of Parliament. So many petitioners have argued that it is not applied to the Rajya Sabha election and it is more a matter of exercise of the franchisee. So therefore, it falls outside the ambit of parliamentary privileges under Article 194. And Supreme Court have observed that Rajya Sabha is also part of the parliament. So whatever the observation and whatever the judgment made by the Supreme Court, it is also applicable to the Rajya Sabha house also. So this was the observation which was made by the Supreme Court. Moving to the next slide. Next slide is about the question, and the question is very simple. What does Article 105 of the Indian Constitution pertains to? And your options are right to equality, privileges of parliament members, right to freedom of speech and expression, and the last one, right to constitutional remedies. This is very easy one. I hope you like this session. If you have any queries related to the session, kindly ask in the comment section. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.